Gibson stepped out for a minute, and the defendant indicated to me that he wished to adjourn this because he wanted to hire a lawyer. And I said, well, let's wait till everybody gets here and then discuss it. Now that all the witnesses are here, Mr. Duchatier, what would you like me to know?
I wish to hire an attorney, Your Honor, at this point in time.
You have to speak up.
I would like to try to hire an attorney, Your Honor.
Have you talked to anybody?
I've currently been looking into it.
That means no,
I've looked into it.
but you've not actually talked to any attorney?
I talked to one of their secretaries.
Okay.
Well, the lady at the front desk. Clerk, I guess it would be.
Now, as I mentioned, each of these matters, according to the affidavit, there's a video of it. Before court started, Mr. Robert came in to meet with Mr. Gibson and provided him apparently screen captures of some videos, one from the store on Main Street and one from Walmart. And have you had a chance to watch the videos of either of these proceedings?
No, Your Honor.
Before 2 minutes ago, did you see the pictures of each of these cases?
Yes, Your Honor.
All right, you'd seen the pictures before today?
Yes, Your Honor. No.
Oh, so the first time you saw those pictures was a few minutes ago?
Yes, Your Honor.
And those pictures purport to have you in them. They came from two separate videos. You haven't had an opportunity to view those videos. Mr. Gibson, have you had an opportunity to view the videos?
No.
Why not?
Well, I'm not sure that I had determined if there was any digital evidence available in my discovered material, but I had received written police reports that I had obviously gone over with the defendant and affidavits, but a lot of times we don't always get digital evidence until maybe the case is into it a ways after it's bound over, but sometimes
the judge methodically works through the limits of enforcing a judgment against a business entity, highlighting the procedural gap. You can subpoena a person, but you can't arrest an LLC. His tone shifts toward impatience as he explains the next step. A show cause hearing for Gregory Myers personally. The message is clear. The court won't ignore a no-show, even in small claims.
But sometimes I'll get that kind of stuff immediately. Sometimes it comes in like a few weeks later. So
Your Honor, I can see that we have the digital evidence on the case that happened at Main Street Ladies Gym. That's been provided to defense counsel through the Axon account at the end of October. Looks like October 31st. We don't have the video from the Walmart incident. And that's what I provided him today, the loss prevention report with screen grabs of that. So he could have, him and his client could have watched the video on the other incident.
I don't know much about the cases at this juncture because I'm not supposed to know too much. As we get into sworn testimony, I hear more about it. But there's an affidavit of probable cause. Which states there's a video of the suspect from Walmart. They provided the video and Duchalier was identified from the video of the suspect.
The consequences escalate as the judge outlines the path toward contempt. A second failure to appear would trigger a warrant, with bond tied to the unpaid debt. The plaintiff remains patient but confused, prompting the judge to reassure him about scheduling. The exchange underscores how small claims disputes can turn serious when one party refuses to engage, and how the court gradually increases pressure for compliance.
I would wait till after there was a prelim or after the matter was bound over to look at the video. If I was the defendant, I would say, I want to see the video. This is embarrassing. In the 27 North Main Street, the ladies' gym, it says in the affidavit of probable cause, she received video footage of a suspect coming into the building. I compared a SOS photo to the video footage. It's the very first thing I would have done is got the video footage and watched it with my client. Mr. Robert, I apologize because you brought the witnesses in here, and Miss Ward is here and the people are here from Walmart and you're ready to go. But the defendant wants to hire an attorney. There may be an ineffective assistance of counsel issue if I don't grant it. They haven't bothered to get the video evidence or look at it. So can you disclose who it is you're considering hiring?
Not yet, Your Honor.
All right, are they from Michigan?
Yes, Your Honor.
All right, now we show a South Bend address for you. You've attended every hearing. Where do you actually live?
My house is in South Bend. However, I've been living here in Michigan.
All right, where do you stay?
I'm transitioning to Michigan now.
All right, I think that's what you told me before. You have permission to live in the state of Indiana, and you've attended every hearing. So there's that. The only regret I have is these people got subpoenaed. They took time out of their day to come here. But my fear is if we proceed, the whole thing could get undone. And then your new attorney is going to say, well, I can do the case, but I can't do it on that day.
If anything, Your Honor, and
Yes, sir.
if possible, we can move it for 2 weeks out, and if not found a attorney by then, I'm more than willing to represent myself pro se.
Well, I'm not a big fan of that, but one thing I would be a fan of is you having an opportunity to watch the video of each of these incidents. The police contend that it's you, and there's not much dispute to the fact that it is you. Well, you ought to be able to see it.
When he was interviewed by Detective Snelcom, he identified himself as the person in the video. He was shown stills.
All right, so it's not a whodunit.
Excuse me, Your Honor, I was never shown a video.
All right, well,
Nor did I identify myself as anybody. So
okay,
that's a false
again,
statement.
I'm not supposed to know too much. But there's two videos that Detective Smallcombe says, those are you. I guess you might want to have a chance to view them because there's a plea offer that the prosecutor has made, which affects your sentencing guidelines. And if you have a preliminary examination, the plea offer is withdrawn. And if you are convicted, the sentence would be different because the habitual would be on there and the sentencing. Has anyone reviewed what the sentencing guidelines would be between the current status and the plea offer?
Nothing.
Your Honor, I don't think it's necessarily fair to what this necessarily is hearing, because the defendant is not necessarily being totally open with you about. I attempted to talk with him about this case numerous times, and he was very hostile toward me. and acted like I didn't work for him and he didn't want to talk with me. So a lot of these things I never could really even get into him because he wouldn't even allow me to have a conversation with him. He just was telling me that, how much I don't know, he was not, he was not polite with me. He was not wanting to listen to me, and he constantly cut me off and wouldn't let me talk.
So you never got a chance to have an in-depth discussion with him regarding the plea offer?
Well, regarding the plea offer or regarding the facts of each case?
Any of it. Well,
and
the different, one of the things that should be done, as far as I'm concerned, is when there's a plea offer, the defendant ought to know the difference between the sentencing guidelines on the offered charge and the case without the sentencing guidelines. And I don't know that they always do that. I don't know that anybody does it. Some of the lawyers do. Anyway, the bottom line is, I apologize, Mr.
The case
Small.
pivots to the insurance dispute. The judge lays out Michigan's no-fault structure and explains why uninsured motorists create legal complications. He digs into the accident details, the driver's relationship to the defendant, and conflicting statements about coverage. As he sorts through whether the vehicle was truly insured, he emphasizes the difference between full damage recovery and the mini-tort limit, grounding the parties in the statute's realities.
I apologize, Mr. Smallcombe, Ms. Ward, and Mr. Robert. We're going to have to adjourn this for 2 weeks. Give the defendant an opportunity to. Mr. Gibson is not working against you. He is who's been appointed to represent you. You had a right to hire a lawyer right out of the gate. Well, you didn't. You asked me to appoint a lawyer for you, so I did. So the prosecutor shares the police reports and the information with him. That information should, or at least before I made a decision about waiving the prelim or holding it, have the video in it so you can see it. According to Mr. O'Barry, you even said it was you. I'm not taking away your right to have a prelim. If you want to have a prelim in each of these cases, I'm willing to do it. Now, let me repeat. In a preliminary examination, you don't get found guilty or not guilty. They just determine whether there's sufficient probable cause to believe that a crime was committed and that you did it. Well, the owner of the store is going to come in and say somebody came in and stole a bag full of money. Well, that's pretty clear probable cause. The question becomes whether there was probable cause it was you or not. Probable cause is a lot less than proof beyond a reasonable doubt. It doesn't take a lot for the court at the district court level to find probable cause. The matter then gets bound over to circuit court, and you have a right to have a jury trial in front of 12 people that would have to find beyond a reasonable doubt that you did it. And that's not always that easy to do. The difference here is